All right, we are live. Good morning. This is Attorney Vince Davis, and this is The Office Hours, where you get to come on the live stream with me and ask me your three or four most important questions. Today, we have Emma from Gainesville, Florida. Good morning, Emma. How are you?
I'm doing great.
Good, good. So, Emma, what's your first question?
My first question is if you are taking a case to trial and you don't have no physical evidence, but you only have witnesses, is that still a strong case to take to trial?
Yes, it is. Witnesses are just as good as documentary evidence, sometimes even better. So if you have witnesses, you want to make sure that you present your witnesses and, for each of the allegations against you. Sometimes the witnesses will be the same for all of the allegations. Sometimes you might have like 5 or 10 allegations. You might have a different witness for each allegation. And then sometimes you might have more than one witness for each allegation, okay, for different parts, or what they call corroborating evidence to show that the witness that testified before is telling the truth. We just saw that in the trial with Donald Trump. They put a witness on the stand. His former attorney, I can't think of the guy's name now, but the former attorney who had been convicted of perjuring himself in prior cases. But they had him testify. But the key thing was that the prosecution put on other witnesses to try to show that he was telling the truth this time in court. So that's something that you should talk to your attorney about, okay? Emma, what's your next question?
My next question is what happens like whenever the petition of the petition it changes, like the first shelter petition is different from the other petition. That Why does that change? Why does the petition changes?
Okay, it changes because the social workers are allowed to amend their petition as they discover more evidence. Sometimes it will change to add things against you. Sometimes it will change to take away things against you. And sometimes it'll be a little bit of both. But
Why would
that's,
they change to take away? That's what
yeah,
happened to me. They took away.
well, they may find out that the allegations that they made against you, which they first thought about, are false, or they can't prove it. And they don't want to make themselves liable for violating your civil rights for trying to have a trial against you for something they know they can't prove. Okay.
Great.
All right. So what's your next question, Emma?
That my child first time for visitation. This is my first time ever. To We're in the beginning of the stage, and we're talking about visitation. And the first visitation the judge had ordered is for 1 hour per week. I wanted to know, is this something that my lawyer can do to modify that?
I'm sure there is. You should talk to your lawyer, although you're in Florida. In California, the way the statute reads is you should have as much visitation as possible, with your child while the child is detained. Routinely in my home county here in Los Angeles, a lot of judges order what's called 3 by 3, 3 hours a visit 3 times a week, or they might go 4 by 4 or 2 by 2, something like that. But visitation is something that's supposed to be evaluated for every case. I don't know that it is. It seems like it's more automatic and maybe robotic.
The place they have the visitation at, they said they don't have enough of availability for parents to have visitation.
Yeah, I've heard that many times before. But the interesting thing is that the federal government gives these states and counties the money for visitation, for frequent and liberal visitation. So they may be spending their money elsewhere, but that's something that you should talk to your attorney about, because the money was given to your county to let you have visitation more than 1 hour a week. Now, if the judge said you can only do 1 hour a week because the facts of the case show that you should only have 1 hour a week, then that's a totally different thing. But if the judge is saying you only get 1 hour a week because that's all the county can afford, I believe that violates the federal rules and the federal statutes. So you should definitely talk to your attorney about that, okay?
Okay,
All
thank
right.
you.
What's your next question, Emma?
That I have a special need child. Is it anything? This is just a question that I don't know. It probably mean nothing, but does a special need child? A lot of people was like talk to a pharmacist. I mean, not pharmacist, a psychiatrist to tell them that the special need child should be reunited with their mom as soon as possible. Is there anything with special needs that I can present to the judge?
Yes. You can talk to your attorney about getting a expert witness who can come to court and testify to the needs of your child or the best needs of your child. And that expert will probably have to interview your child and evaluate your child as well as you. So that may take special permission from the judge to allow you and your attorney or you and your expert witness to interview the child. That's
It's
there's
not
definitely
verbal.
but that's definitely that there's something that can do. If the child isn't verbal, what can happen is that the child can be evaluated by being around you, seeing the child's emotional and psychological reactions to your being present, to your love and your affection. You
I
know,
would pay for an expert.
you if you were in California, the answer would be no. You don't have to. You could make a motion to allow to ask the court to pay for that expert for you. I would assume they have something similar in Florida, but that's something that you'd have to talk to your lawyer about.
What about the guardian aid?
The guardian ad litem.
Yeah, should I reach out to them and let them see that my child is special needs and they should be having more visitation?
No, you should do that with your lawyer. Okay, you were given a lawyer for a specific purpose, and that was to help you and defend you in this case. Do not try to do these things on your own because there's a lot of things that you don't consider or you won't be able to consider because you're not a lawyer. I meet and I talk to a lot of people that tell me, just tell me what to do. And I tell them, I give them the advice they're seeking, but I tell them very careful because you don't want to try to do something that you're not qualified to do. It would be like me, Emma, going out to my garage and fixing the transmission in my car. I don't know how to do that. I could go to Pet Boys, I could buy all the tools, all the supplies, read all the books, but I've never done it. And if I tell you I can't change a transmission, I can't. Another example that I used to give all the time is the doctor tells you, "Hey, Emma, you need open heart surgery." What are you going to do? Go on Google it, watch a few videos on YouTube, and then try to do it yourself? Of course not. But people think they can do their own legal case, and I just cringe when I hear that because I know that they can't. Now, has a person ever won a case representing themselves? Yes, I've seen it. It's like 1 in 1,000. Do you want to bet your relationship or your child's life on 1 in 1,000 because you think you can do it yourself? You can't. And I just cringe. I spoke to someone about 3 days ago, and she told me a story. And I was told by someone in my office that this was the first time that this lady ever called. And I knew after hearing the story that it wasn't. Same county, same story, kind of a wild story where, the parents and the grandparents were getting the short end of the stick. But she told me the story. And I said, "Well, you know what? You and I have talked before." And she finally admitted, she said, "Yes, we've talked before." And I said, "I told you before what to do and what to have your attorney do, right?" She said, "Well, I didn't get an attorney and I'm trying to do this myself." Now, she was a fairly sophisticated person. She had worked for the federal government, okay, and in a federal agency. She's educated, fairly sophisticated, but she didn't know the rules of evidence. She didn't know the rules of procedure. She didn't really know the law, although she was Googling herself, trying to figure things out. And, I talked to her a couple months ago and I said, "I'm telling you the same thing I told you 2 months ago. And she's telling me that it didn't work." And I said, well, it didn't work because you tried to do it not knowing what to do. So, for example, I told her, you have to file a 388 petition. Okay, that's something in California. And she said, well, I filed that. And I said, well, who drew it up for you? And she said, I did. And it was just like, come on. It's like, can you perform open heart surgery too, just by reading Google or watching YouTube videos? So don't try to do this yourself. Try to form a relationship with your lawyer that you guys can work together. Okay?
Yeah, I
Don't
absolutely told her that whatsoever this case has been, they still don't have a case plan for me. They keep on saying continuing, continuing. And I told my lawyer, whenever they do come with a case plan, I don't even want a case plan. I want to go straight to trial because of each allegation that they have against me. I'm so happy that the cards was dealt like this, that for each allegation, I literally have a witness, like literally a witness.
Okay, well, Emma, this is what I would suggest to you. You talk to your lawyer and considering implementing both strategies, the trial strategy and the case plan strategy. Interestingly enough, my experience over the last 35 plus years in doing these cases is that things go your way in trials when the judge knows that you're doing the case plan. Is it supposed to be like that? Theoretically, no. But I could tell you, we could have a conversation for an hour about why that is the case. Just take my word for it. Go to
Yeah.
trial, but also participate in the case plan. And the other thing that I want you to consider, and this is going to be the last part of it, what I want you to consider, I want you to consider your presentation in court. You physically and the way you sound. You have a very high voice. I want you to try to bring that down. Okay.
Gosh, everybody keeps saying that to me.
Well, it's true. Look, we just met. I've talked to you for now 12 minutes and 14 seconds. Your voice needs to be brought down. Okay. I'm just telling you how it's going to affect the trier of fact in your state, which is your judge. All right. So bring it down. And then there's a certain way that you should dress for court. Now, I know you're not dressed for court now, but
You say a white wait. I read what you said. I heard what you said last night. You said a white, navy, gray pants, white shirt. You said a 3-inch heel.
no, I said two. But if you've seen that video, watch that video again. It's free. It's on YouTube. Watch that video, and it will tell you how you should dress for court, how you present yourself, right? Now, when you go someplace and you look at someone in a business or in a certain situation, if they're not dressed, immediately your mind takes you to a negative space if they're not dressed appropriately, right? Same thing in court. Same thing with the judge. Same thing with the social worker.
Yeah, I'm
Present.
definitely going to Burgerton today to get me a white. You said, oh, I'm definitely going over that video and taking it to Burgerton and getting it.
Right. You
But
can get
the thing about it, you said go with the case plan, but they have not issued me the case plan yet. How am I supposed to go with it? And
okay. So what you need to do is go over your case and the reports with your attorney. Either they have buried the case plan or recommendations in those reports, or your attorney, who I assume is experienced, will tell you what you need to do to get the child back.
no, we have not. We have not. We have went already to the shelter hearing, and then we're at this. The one that start with the A, the one that are supposed to say guilty, plead guilty,
Right.
or
But listen, I mean, you're not you is that something on your side? I hear a bunch of chiming. Yeah.
I'm chiming.
Yeah, I hear like an alarm going off.
Oh, sorry. What's your name, please? Thank you. Sorry.
All right. So what I want you to do is you've already gone to your shelter hearing, okay? Shelter hearings are very easily lost in the most cases because the standard and the legal tests are a lot different. Now you're going to what's probably called your trial. your jurisdictional or adjudication trial to decide whether the allegations against you are true or false. And believe me, you're going to need your attorney's advice and input in how to win that case. Now, a lot of people tell me, well, Mr. Davis, my court appointed attorney is, not helping me, blah, blah, blah. Then it's incumbent upon you to find someone to help you. Guess what's not going to help you get your kid back? Judge, my attorney didn't help me. That's not going to help you at all. It's not going to be an excuse.
Can you request a new public new attorney that the court had issued? Can I just fire that one and just ask the court if I can get another one?
The answer is generally yes, but you have to have what they call, at least in California, you have to have good cause to get a new court-appointed attorney. You can't just say, I don't like him or I don't like her. You have to have some reason to give to the judge. Now, by the way, I have a couple videos on that on YouTube, how to get a new court-appointed attorney. So search that. And that's a whole different topic by itself.
Because I be going through your videos like crazy. Like, all thing I'm on YouTube is your videos is popping up all over the place.
Well, somebody told me the other day, they said, you almost have 2,000 videos. And then I thought to myself, because I meet a lot of people that tell me, I've watched all your videos. And I'm thinking, boy, that's a lot of binge watching right there.
Mm-hmm.
Okay, Emma, you know what? We're coming to the end of our office hours. I want to thank you for coming on today from Florida. Good luck in your case.
Thank you.
And God bless. And if you have any questions for me, you see my number down there, bottom right-hand corner, 888-888-6582. Just give us a call. All righty?
Thank you. Bye.
Bye-bye.